The soldiers.
Say again, who was suspended, you say?
It was in paragraph 66.4 of the founding affidavit.
66.
We referred to an instance where the members of the Ekurhuleni Metropolitan Police Department were involved in the shooting and assault of an individual. In their answer, Ekurhuleni says, yes, thank you for bringing this to our attention. We have immediately suspended these officers.
Right.
Now that is exemplary and salutary. But your Lordship does not find the same statement in the answering affidavit of JMPD. Your Lordship does not find the same statement in the answering affidavit of the defense. What we can therefore deduce from this is that the soldiers who participated in the act of assault leading to murder and the JMPD who watched and stood by when a crime was committed in their presence are still in their posts. One of the allegations made is that Mr. Khosa was hit with the butt of a machine gun. That soldier who hit Mr. Khosa with the butt of a machine gun is still holding his machine gun today. More than a month after the allegations of grave assault, more than a month after the allegations, quite frankly, of criminal conduct, no one has been suspended. What we get from the minister is that not only does he defend his department, he also defends the individual soldiers. Because what she says to us, I cannot suspend anyone without giving them a hearing. He would rather prioritize the hearing rights of the 5 soldiers that were involved in acts of criminality than the rights of the public to live without fear of their security officers. But in law, the minister is grossly mistaken in any event. We have shown in paragraph 81 of the heads of argument, by reference to a judgment in Long versus SAB, the suspension we want the court to order is a suspension pending an investigation.
Well, it's often done, we know that.
Precisely. It's usually done and it's been ordered by the court before.
Yeah.
And it is precautionary. Get out of the office now until we find out whether you did it or you didn't. If you didn't do it, come back to work. And the Constitutional Court has made it clear where the suspension is precautionary and not punitive, there is no requirement to afford the employee an opportunity to make representations.
Yeah.
But if they want to give them a chance to make representations, they can. No one says that they should not give them a chance to make representations at all. What we say is that it is intolerable that the soldiers who beat a person with the butt of a machine gun must still be holding those machine guns.
Mr. Toby, look, I understand what you're saying. I know the case law. I mean, it's been applied even in labor law for years and years.
Yes.
And so that's nothing new to me.
Yes.
I'm just worried about, in prayer 3, the practicality of the order.
Sorry, my Lord, I just want to get my notice of motion.
If you had asked that I should order that without any rights of the individuals being reduced or taken away in the context of their, say, contract of employment, or as members of the defense force, that I could order a precautionary suspension. That would be something different than saying what I at least think, seems to be, to me, very impractical. That these references to 1 hour within 3 hours and 3 hours and 24 hours and so forth. I mean, are you going to insist on these time periods, or are you actually more interested in a suspension?
No, my Lord. What is the important order is that they must be off duty and that their guns must be taken away. In fact, in our heads of argument, we have referred to the Motsoeneng case at paragraph 83. Your Lordship remembers the notorious story of Mr. Motsoeneng. He was implicated by the public protector in acts of misconduct.
You mean the SABC case?
Yes, my lord, the
Yeah.
SABC case. But the public protector had not recommended that he should be suspended, simply recommended that disciplinary inquiry must take place. When the case came before Justice Skippers in the Western Cape High Court, he said it is intolerable that Mr. Motsoeneng, given these grave allegations against him, continues holding the position of Chief Operating Officer and suspended him pending the disciplinary inquiry. That suspension was then contested by the SABC before the Supreme Court of Appeal.
Yeah.
They contested it on grounds similar to the grounds that we are hearing today: separation of powers, breach of Mr. Motsoeneng's contractual rights, etc. But that was completely dismissed by the SCA. We refer to this in page 37 of our heads of argument. Well, firstly, in page 37.
Look, why I'm asking that, now I've read that case, I know about it.
Yes.
Will you, in the course of the day or tonight, perhaps think about rewording prayer 3?
Yes, indeed.
I can't believe it will prejudice anybody if you ask for lesser relief.
No, it will not. Yes, indeed, Malik.
But it's just a suggestion that you think about it. Obviously, I'm not telling you what to do.
Thank you, my lord. I can tell your lordship without any reservation now that we are not going to insist that you should suspend them within 1 hour.
Well, perhaps in the course of the evening you can draft an amendment to prayer 3.
Thank you, my lord.
But make sure that every other party gets the time to think about it.
Thank you, my lord. We shall indeed do so. So the Motsoeneng case ultimately goes to the Supreme Court of Appeal. Justice Nafsa now writes the judgment, and at paragraph 61 of the judgment, this is what he says. In the light of the public protector's findings and the events subsequent to her report, the High Court was rightly concerned that Mr. Motsoeneng should not continue to be in office with serious allegations concerning maladministration and the integrity of the SABC hanging over him. The High Court approached the inquiry thus: the allegations of misconduct against Mr. Motsoeneng are serious. He is the COO of the SABC. He is an executive member of the board. He has virtually unlimited authority over his subordinates and access to all documentation. Given the nature of the allegations and the persons involved, Motsoeneng's fellow board members and his subordinates would have to be interviewed and documents produced. Then in paragraph 96, what this shows is that unless he is suspended, Mr. Motsoeneng poses a real risk not only to the integrity of the investigation concerning the allegations of his misconduct, but to the disciplinary inquiry itself. It is untenable that he should remain in office while disciplinary proceedings are brought against him. There can be no argument made that if your lordship accepts on +1 evidence that there are allegations of grave assault by men with guns against an unarmed and a defenseless population, it is intolerable that they are still roaming the streets with guns. It is intolerable that they are still holding themselves out without any suspension as members of the defense force. What we also know is that their identities are known. No one says we don't know who they are. The IPID, it ran a sham investigation, but at least it went to the scene and pretended to interview people. But everybody knows who these people are. And there is no justification whatsoever why they should not be suspended. So your lordship has the power to suspend them. Your lordship, in fact, might have a duty to suspend them in order to protect the public interest against continued acts.
The power and duty arises from what?
Firstly, it arises from precedent, which is the Motsoeneng case.
The SABC case.
Yes, which is the SABC case, which is where you have allegations of serious misconduct. It is intolerable that they should remain in office. But it also arises from the obligations imposed on the defense force itself, which they have not carried out. The obligations imposed by Section 7.2 to respect, promote, uphold, and fulfill the rights in the Constitution, where those rights have clearly not Where those rights have clearly not been fulfilled, then it is incumbent upon a court to step in and direct their fulfillment. And Justice Skippers, who was fully endorsed by the Supreme Court of Appeal, also invoked Section 38 and Section 172 of the Constitution.
Well, I was just going to ask you about 172. Would that give me the power?
Precisely. We would submit with greatest of respect, it would be just an equitable remedy under Section 172, 1B of the Constitution. Now, Your Lordship knows that the suspension was found to be lawful by the Supreme Court of Appeal in the light specifically of Section 172, 1B of the Constitution. So that gives you ample constitutional authority to order the suspension. Once you have an act of illegality, and that act of illegality has not been remedied, the only way it can be done is the suspension. And the idea that a court would be overstepping its mark if it ordered a suspension has been considered and completely rejected. So we would say, with the greatest of respect, Prayer 3, subject to Your Lordship's suggested amendments, we will amend it overnight. Prayer 3 should be granted. What is worse about the JMPD is that they have not even committed in an answering affidavit that they will suspend themselves. Nothing at all. What is also worse with the Defense Force is that they have not committed that they will do the suspension themselves. What they say is, well, we don't know what the investigation will illustrate. But you have a clear prima facie case of grave misconduct, which is not answered, which justifies a suspension. So it is a never-ending suspension, which is in fact intended at protecting the soldiers rather than holding them accountable. We then moved from this to the issue of the code of conduct.
Will you let me know what the time is? I don't have a watch.
The time, it's 1 o'clock. It might be the right time for an adjournment. Thank you.
Must have a good instinct. We're going to the code of conduct next.
Yes.
That was prayer 4.
Yes, prayer 4.
I will adjourn until 2 o'clock.
What have you got? I mean, you see, at least I've got coffee. Oh, yeah. You want?
Yeah,
Look at all. I want to make a suggestion to you.
Yeah, sure.
Not a settlement yet.
No, what do you mean not a settlement?
When you finish, then the steward should follow you.
Oh, yeah.
So we can answer to all of this. And we can tell you what we conceive when we don't conceive.
Give the child a settlement. No, I agree. In fact, we didn't discuss that. We should have discussed that.
Because I think he's taken a view that he wants to do everything. And he decided, I must go find out.
You're happy with coming tomorrow?
Yeah. I was just trying to get an instruction to give you a report, that's all.